All right, we're going to be looking at the judicial branch, which is Article 3 of the Constitution. And it gives the judicial power to the Supreme Court, and then it gives Congress the power to create any lower courts. We do have a dual court system, and that just means we have a national court system, and there are over 100 federal courts, and then each of the 50 states has its own court system. There are two types of federal courts. You have the Supreme Court, and it is established in the Constitution, and once again, the inferior courts. The Constitution gives Congress the ability to establish all of these lower courts or inferior courts, which is anything under the Supreme Court. You have constitutional courts and you have special courts. Under the constitutional courts, you have the district courts and the courts of appeals. We're not going to be studying anything about the special courts, but I definitely wanted you to know that there are some specific courts just for a narrow range of subjects. So there's a U.S. tax court, territorial courts, which if you have a federal case in Guam, America Samoa, the District of Columbia, you would go to one of those territorial courts. Armed Forces courts, so they're very, very specific. But the only ones that we're really going to concentrate on are the constitutional courts, the district courts specifically, and the Court of Appeals. When we're talking about jurisdiction, we're talking about the authority that a court has to hear and decide a case. So not every court is able to hear every case. It's just based on the jurisdiction, and there are 4 different types of jurisdiction. The first one is exclusive. Some cases can only be heard in federal courts and cannot be heard in state courts. One of the examples is involving an ambassador or a foreign official. If there is a foreign official or ambassador from another country and they break the law or something happens, they would have to be heard in a federal court and not a state court. Concurrent jurisdiction means it can be heard in either a federal court or a state court. And one of the examples would be diverse citizenship. If you have people from 2 different states, someone from Indiana and one from Ohio, early on it would be difficult to make one state enforce a law on someone else from another state. So what they decided is we could have this in federal court. If it is a civil matter, then it has to be over $75,000 for a federal court to hear it. Then you also have original jurisdiction and appellate jurisdiction. Original just means whatever court is hearing a case for the first time, and this is your district courts, which is one of your inferior courts, and on a very, very small number of cases, the Supreme Court has original jurisdiction where a case can go automatically to the Supreme Court, but that's very, very rare. And then appellate jurisdiction. These courts don't hear it firsthand, and they don't even hear all of the case. They are trying to decide whether there has been something wrong in a lower case. So anytime you hear a lawyer say, I appeal, they're saying that because they think something at the district court level where this case is being heard for the very first time, they're thinking something is wrong. So they want to put in the record when they appeal this case to a higher court that they think something is done wrong. And so 3 things that an appeals court can do when they hear this, and once again, they are not retrying the case, they don't hear any new evidence, it's just things that the attorneys think have gone wrong in the district court level. They can uphold the ruling at the district level, they can overrule it and make it go back and be heard again, or they can modify the decision that a lower court has made. In terms of selecting a judge, there's this thing called senatorial courtesy. There are hundreds and hundreds of judges, and obviously the president can't be an expert on any one of these. Every state has at least 1 district court, and there are 13 appeals courts, but there are hundreds of judges that serve on this. So if there is a vacancy in one of these federal courts, the president will go to the senators, and the senators from those states will give recommendations. And as long as the judge falls in line with the president's philosophies, the judge will pretty much go along with the senator. There's no age, citizenship, or resident requirement to be a judge. And typically, well, not typically, presidents always try and pick someone from their own party because judges serve for life. And so a president is going to try and pick someone who has their own philosophy, who's going to be on the bench potentially for decades, who is going to try and interpret the law based on what the president himself or herself would interpret it. Judicial philosophy, there's the idea of judicial restraint and judicial activism. More conservatives follow the idea or the philosophy of judicial restraint. The judges should decide cases based on the intent of the original founding fathers or those who enacted the law. They should not try to rewrite legislation and make all of these different changes. They need to go back. How would the founding fathers feel about these matters? So typically your Republicans are going to be more in line with this idea of judicial restraint, and another term used for that is constitutionalism. Then you have the idea of judicial activism, and this is where the idea of the living Constitution, that this is a living, breathing document, and that it cannot be interpreted based on things that were going on in 1787, when the Founding Fathers obviously wrote the Constitution, but this is a document that must be interpreted based on ongoing changes in conditions and values of the day. Judges serve for life, and the reason they did that was to ensure the independence of the federal judiciary. These people need to go in there and be able to interpret this document and to interpret what's going on in government without the fear of losing their jobs. And so this idea of having them being independent and realize that they don't have to run for re-election, so they are free to interpret the document without fear of losing their jobs. They can be impeached. They may retire at age 70, and if they have served for 10 years as of 70, they get their full salary for the rest of their lives. If they are 65 and they have served for 15 years on the courts, then they get that same benefit. District courts, created in the Judiciary Act of 1789. There are 94 courts. They do have original jurisdiction, which means these are the courts that are going to hear the whole entire case. They're going to hear all of the evidence, whether it's a criminal case or a civil case. And criminal just means it's criminal, bank robberies, kidnappings, terrorism, all of those things. And you have a plaintiff and a defendant. The plaintiff is the one who files the suit. The defendant is the person who is having the claim made against them. Civil cases obviously are non-criminal matters, contract disputes, money damages, those sorts of things. And when you have a case in the federal courts, the U.S. is usually a party in the case. So you'll always see U.S. versus, and I just put U.S. versus Nixon in this case. Two different types of juries. Most of us are familiar with hearing grand jury, but that's not really the jury that you see on television in criminal dramas. The grand jury is the one that hears just a little bit of evidence to decide if there is enough evidence to have a trial, or what they call an indictment. When someone is indicted, that just means there's enough evidence and we're going to eventually have a trial over this. The petit jury is the one that you would be familiar with seeing on television. They hear all the cases, and they're the ones that determine whether someone is guilty or innocent. Then the second type of inferior court is the Court of Appeals. This was created in 1891, and it is called the gatekeeper to the Supreme Court. It was created because there were so many cases that were going from the district courts to the Supreme Court that they wanted another sifting process, so not so many cases are going to the Supreme Court. There are 13 courts of appeals, and they're also known as circuit courts because when they were originally established, what would happen was the judges would ride in a circuit from court to court, and they have only appellate jurisdiction. So they are not going to hear all of the case. They're not going to hear any new evidence. They're going to hear 30 minutes from each side on questions of wrongdoing at the lower level. And this is just a map. You have 11 of the districts. What you don't see here is the Court of Appeals for the District of Columbia and the Court of Appeals for the Federal Circuit. So that would be 12 and 13. But each state has at least one. Obviously, there are 94 district courts, but then these are the circuit courts. And then this I just put the bottom represents either the special courts or your district courts. If you go up one level, those are your courts of appeals. So all of those courts on the bottom level would appeal to the next level. and then you would go up and they would appeal to the Supreme Court. When we look at the Supreme Court, it is the only court that was created by the Constitution. There is a Chief Justice, and that is currently John Roberts. There are 8 associate justices, and they are the court of last resort. They have the last word on any issue, especially involving constitutionality of something, acts of Congress, and then treaties. And they are the court that was put on the same plane as the legislative and the executive branch. Judicial review is the ability of the courts to decide if acts of government are constitutional or not. You will not see the term judicial review anywhere in the Constitution. In 1803, Marbury versus Madison is the first time you have the court ruling an act of government unconstitutional. And so John Marshall was the Chief Justice at this time, and his ruling was that the courts didn't have the ability to do what they were asked to do. So it was ruled unconstitutional. In order for a case to reach the Supreme Court, there's usually somewhat around 8,000 or more cases that are appealed to the Supreme Court every year, and they only accept a few hundred. And you do have the rule of 4, which means it just takes 4 justices to hear a case. 4 of them have to determine that this is something that they want to do. A writ of certiorari means to be made more certain, and that's just the order orders a lower court to send the record up for them to actually hear a case. So if a lower court attorney wants the court to hear a case, they create this writ, send it in, and the court decides whether to hear the case or not. If the court denies hearing the case, then the lower court ruling stands. So obviously it's been in an appellate court, so whatever the appeals court rules, that's the ruling that will stand. Their term begins the first Monday in October and runs between June or July. The Supreme Court will hear oral arguments, and each side gets 30 minutes, and when your 30 minutes are up, your 30 minutes are up. It doesn't matter if the attorney is mid-sentence or not. They will cut them off, and that's all they have. What's so interesting is the whole entire time that the attorneys are trying to get everything in, the justices are asking question after question after question. So they have to try to get all of their evidence in that period of time while being asked questions. There are 3 different types of opinions. You have the majority opinion, which is the opinion of the court. It sets the precedent. This is the winning side, that any other case that comes along that deals with this particular subject, they will look to this particular opinion as how the court's going to rule on that in the future. There's a concurring opinion written by another justice who wants to make an additional point that's not necessarily written in the majority opinion. And then there's a dissenting opinion, and that's written by the side who does not agree with the majority opinion that actually loses this particular case.